too warm, are they? Yeah. Right, if we're all ready then, all ready. So, renters' rights, it's coming. We can't run away from it. We still don't have a date, but one thing we can do is get prepared. So, thank you very much for putting your questions forward for tonight's Q&A, legal presentation tonight. We've got 40 minutes, thereabouts, so we'll answer as many of those questions as we can. We may have room for some questions at the end, we may not, and we'll see how time goes. But in the meantime, I'll pass you over to John from Trowers and Hamlins.
Thank you. So as Cara said, I'm John Mousicos. I am Trowers and Hamlins Property Disputes team. So we deal with really only contentious matters or anything that's potentially contentious. We deal with all sorts from, I would say that the majority is probably commercial landlord-tenant type stuff, service charge disputes, end of tenancy, end of lease stuff, dilapidations, that kind of thing. But we also do quite a significant amount of Housing Act possession claims and other disputes between landlord and tenant. So yes, the Renters' Rights Bill, as Cara said, it is coming. By show of hands, out of interest, who here would say that you know quite a lot about the Renters' Rights Bill, or at least what we're able to know so far? Okay. And then presumably then everybody else knows what it is. So I don't want to. I mean, the majority of you didn't put your hands up, and that's good because I don't want to talk or teach you to suck eggs, let's say, and talk too basic. What I'm going to do is go through an overview of the bill first, and I'll whiz through that, and then we can get on to the questions because I think that's the interesting part. I know from the turnout tonight that there's a lot of concern in the room, I would imagine. The government is framing this reform as something that's going to be good for tenants and landlords alike. And I think we all feel a bit nervous about that, and I certainly do as a legal practitioner. I'm not convinced by that at all. And I think that you have good reason to be concerned, but you're also doing the right thing, I think, and being proactive, it seems, and addressing the concerns. And I'm hoping that the way that things will be that there will be a period of pain and the dust settling, and then hopefully you'll work out your strategies and you'll work out, for example, which grounds work best and which grounds the courts like the most, and find your way through it. And obviously that's the grounds have to apply, but like anything else, I think it's a matter of letting it play out and see how it plays out. So, okay, let's start. It was introduced last year in September. It's a restructuring of the private rental sector. The main thing is that it will abolish assured short-hold tenancies, and it will introduce periodic tenancy, so it will make every assured short-hold tenancy a periodic tenancy. So we're talking about 1 month tenancies, rolling tenancies maximum, and some less. It will get rid of Section 21. I think you probably all know that already, and that's one of the biggies, I'd say. Applies only to England, and we're anticipating royal assent by late 2025. I think that's fair, maybe even next year. It's going to the House of Lords on the 1st of July until the 15th, and then I think there's the recess, Parliament's recess is the 22nd. Nothing's going to happen before the 22nd. They come back in September, so we're looking at the earliest November. I can't see it getting royal assent then. I think it's going to go into 2026, and then we're going to have a period when it will come into force later than that, as statutes normally do. So these are the 12 key provisions. We've said it prohibits Section 21s. It will convert to periodic tenancies. There will be a mandatory membership of a landlord ombudsman scheme, which you will all pay for, by the way, with your fees. That's the idea. It will extend Awab's law to the private sector. As you may know, Awab's law already applies to social housing, as does the application of the Decent Home Standard. That will be applied to the private rental sector too. There will be a regulation of rent increases that will work in a different way, or in only one way that it currently works now. You can have contractual rent reviews. That will be no more. There will be a database that you will have to join, landlord and property database. You won't be able to, the courts won't be able to make an order for possession without you being on that database. Then there will be something introduced to give tenants a right to keep pets, which they don't necessarily have now. There will be a ban on rent bidding, so that there will be no more agents offering tenants the ability to offer more. That won't be able to happen. There will be a prohibition on discrimination, such as here with tenants who have children and tenants who get benefits. That, to some people, I've heard is going to be a concern. I can understand why some of that might be. Then there are going to be enhanced local authority enforcement powers, and then rent repayment orders, which is going to be quite significant. Again, I'll whiz through these as quickly as possible, because I think we're going to address lots of these quite in a more relevant way with the questions. So 21 will go, but everything will be on Section 8, which will be based on a breach of the tenancy. Well, it's based on a breach of the tenancy now, but there will be expanded grounds that you will be able to rely on. And there'll be quite a few, such as sale of the property, or if you or a family member or a spouse wants to live in the property. Again, we said that all tenancies will become periodic. There'll be no fixed terms. 2-month notice required from tenants. There will be an ombudsman, and there will be an extension of Awab's law and the Decent Home Standard. There will be, you will only be able to increase rent through a Section 13 notice and the procedure through Section 13. There will be a central database that we spoke about with landlord and property registration, and then the question of pets. With pets, you won't be able to unreasonably refuse. There's going to be some nuance to that, and I imagine that the courts are going to put the meat on the bone, so to speak, with how what this word will mean, because that's probably the most debated word in the legal profession, I'd say. So it's going to be things like considering the size of the property. If a tenant asks to have a huge Rottweiler in a very small flat, then it may be quite reasonable to refuse. But if they want, a mouse in a well, I don't know what you keep mice in, but cage of some kind, that might be more reasonable. But you will be able to ask for, require them to have pet damage insurance, or you will probably be entitled to take out that insurance if they don't, and then pass that charge on, that reasonable charge. There's that word, reasonable again. Then we spoke about bidding practices, so that will be prohibited. You won't be able to ban, there won't be any more blanket bans on marketing to tenants with children or tenants on benefits. You won't be able to say any more no universal credit anything like that. There will be enhanced local authority powers. This is a tricky one, and we're going to need to see how this unfolds, because there are going to be some quite serious and strong powers of the local authority with inspection rights, and often there's a difference between what the local authority understands about the housing market and landlords' positions and what you understand. So it's going to be interesting to see how that unfolds, and as you can see with some of these figures, they're going to have some powers there, and then rent repayment orders. The maximum awards will be increased to 24 months. It was 12, I believe, in the first iteration in the reform bill. Again, I have to stress that all of this is subject to change and review, and it's still, as we said, going through Parliament. So nothing's guaranteed. This could all change in a few months' time. This is another key one, that the liability is extended to superior landlords. So the rent-to-rent scenarios, I guess you all know about rent-to-rent scenarios where individuals will rent a property and then sublet it. So without any investment on their part, they can make a profit there. The idea of this, I think, is to deal with, amongst other things, the liability, and it will make you as property owners have to think twice about who you're renting to in these scenarios, because some of that liability will pass up to you in certain situations. I think we've already covered this, and we know that it's coming soon, but maybe not this year. Practical considerations. I think many of you have asked in the questions that we received what you can do to prepare, and I'm thinking that that's probably something that you're all eager to do the best with, to understand the best how you can prepare, and what are going to be the obligations on you to cover yourselves the best way that you can. I think you will do well as best you can, and nowadays the information that we have available, to the extent that we do, is all out there. So familiarise yourselves with the full legislative text, and then review your tenancy agreements. I think it's good. It will be good practice, even though the new law will make many of the clauses that are in your tenancy agreements now redundant, such as rent review clauses, for example. I think it's just going to make things easier and less confusing, and prepare you if you really do clean up your tenancy agreements to be in line with the new law. Inspection of properties, I think, to preempt compliance issues is one thing, and then I think also your ongoing inspections are going to be more and more important as the new law unfolds. Prepare for your registration. That's something you won't be able to resist. And then keep an eye on the progress through Parliament and any regulatory updates, because that's another thing. What the government is saying in lots of this, which is leaving things quite uncertain, is that lots of it is going to be subject to regulations, statutory instruments. So I think primary law is going to cover only so much, and it's going to be left to statutory instruments mainly to fill in the gaps. So I think that's something that you'll need to keep an eye on. Okay, let's get to these questions. I think, Cara, you picked out the best ones. I think of all the questions that were submitted. So we've tried to cover in these questions. I think there are about 23. The ones that will best cover a wide range of your concerns, let's say. So what is the earliest we can take the first month's rent? You will be able to take up to 1 month's rent but only once a tenancy agreement has been signed and before commencement. However, this is something that you need to be aware of. With student tenancy agreements, there is a ground 4A, which is going to be a new ground, and that's going to entitle you as landlords to, between the summer season, between I think it's July and September, the exact dates I don't recall right now, but there's a period over the summer during which you will be able to apply for a Section 8 possession order, so you'll be able to serve Section 8 notice and rely on ground 4A. If, however, you sign up, you enter into the tenancy agreement with a student more than 6 months before commencement date, this ground won't be available to you. And the idea behind this law is that it takes the pressure off students, because to those of you who rent to students, you know that the students often, there's a race, to secure their property well before their term starts in September, and the idea is that this is tenant friendly and it's taking the pressure off student tenants. I think you're all, a few of you are sort of shaking your heads, because I think you know that there are going to be concerns with this. One of them being that, for example, you may have a tenant in there over the summer, for example, because you can't use this ground, and they're stuck in there. They don't want to leave for whatever reason, and and then you've got problems, because if you've got student accommodation, you need to be rotating it, don't you? You need to know what's happening in September. So that's something to be aware of. The deposit can be taken earlier. It must still be protected within a government scheme the same way as now. So you've got 30 days to protect it in one of the 3 recognised schemes. And the same with the 5 weeks, maximum of 5 weeks rent. And then I think the same rules apply with the holding deposit. You can take a holding deposit, but that's 1 week's rent. I also have a student property and let the property about 10 months in advance. Can I take the damage deposit when the tenants sign the agreement and when I take the first month's rent? So the same as the above, you can still take the deposit in advance, but you're still limited to 5 or 6 weeks. The 6 weeks is if the rent is more than 50,000 a year. The same issues apply here. If you do let the property 10 months in advance, you can take the deposit, and as soon as you've signed up, then you've got the deposit. You put it into the scheme. You can take the first month's rent only, but then the ground 4A will not be available to you. And to the extent to which that's going to be relevant, we're going to find out. But I would predict that it is. I would predict that 4A is going to be useful to you as landlords of student accommodation. What is the earliest we can let my property and sign the tenancy agreement? I own student properties and normally let them 9 to 10 months in advance of the move-in date. This is still permitted, but again with the same restrictions. So it seems like this is. I'm presuming that many of you are student landlords. So from the questions, to me, it seems like this is a huge concern. This is something that you need to be able to do as early as possible. This 4A ground and the inability to use it if you sign up too early is I predict going to be an issue. But as I said, I don't think we're going to be able to avoid it, and you're going to see how it plays out. And hopefully there'll be other ways, but we'll see. When can I put the property on the market for sale? Would we have to issue a Section 8 to evict the tenants first, or could I wait and see if a buyer comes along? Well, I think the answer to this is if you want to sell the property using the new ground 1A, and 1A is going to be, if you want to sell, you're going to need to state a valid reason. And I think the wording that the courts are going to be using as these cases are heard going forward in the courts is something that comes from existing law in commercial property, and that's that you'll need to show that you have a settled intention to sell. And I think that's what the courts are going to be looking for is that you have an offer, that you have a buyer on the table, that you've instructed solicitors, and that something real is actually happening and moving forward, rather than you just saying, well, you know, we feel that we want to sell. Here's a notice. The other issue is that you'll be prohibited from issuing the notice within the first 12 months of the tenancy. Well, no, actually, this here is it will be an offence for agents to market the property for rent during the 12-month lockout period following an eviction for sale. So, once you've served your notice, and yes, there will be tenants will be protected for the first 12 months from this ground. But once you serve a notice on this ground, and from that date, you cannot remarket the property. So if your intention is to misuse this ground, this is the protection from it. But I think the main point is that you probably will need to market the property first, and get to a point where you have what they will call a settled intention, so that you can prove that you really do have a deal on the table. So yeah, I think you will be marketing first, and then thinking about the right time to serve the notice. A question from Star Lettings here. If a landlord wanted to sell the property with tenants in situ, and also with a new tenancy already signed, in other words, you don't want to give the tenants notice to leave, could we put the property on the market for sale at any time? If possession is not sought, then you can market the property. You obviously don't need to worry about a Section 8 notice. You do need to think about how you will show that property to potential buyers. You can introduce clauses into your tenancy agreement. You can now. I can't see why that won't be possible going forward. Where, you know, for example, you will be able to market the property, giving reasonable notice to the tenant, and so on. But you know, you do need to remember that there's a common law obligation, or a common law right, and often in your contracts, a tenant is entitled to peaceful enjoyment of the property. So you need to be mindful of that. Other things to consider are the landlord's register. Obviously, if you're selling the property, you know that's going to need to be updated. And the landlord's obligation is generally transferring over deposits. That would be in the usual course of things. This is the clause we discussed. The other things to consider, okay, this looks like it's been repeated. That's fine. Yes. So the notices that you need to serve as landlords, that's obviously something that you'll need to consider when you're buying a property, or the incoming buyer will need to think of these things. What kind of records do you recommend we keep in the future? If in the future we had to issue a Section 8 for breach of tenancy for not looking after a property, i.e. damp and mould or just bad habits, or should management visits be very thorough and enough evidence if it goes to court? One of the things that some of you, if not most of you, will be familiar with is this issue of damp and mould and whose fault it is, because often you get into a dispute with the tenant where the tenant's complaining about you leaving them in these conditions, and you feel that it's the way that they've not looked after the property that's created this situation. I don't know how much you know about Awam's law. It's a social housing law that's been expanded, as we've already said, and that will entitle tenants to complain to the Ombudsman or to issue a court claim. I think the Ombudsman is probably going to be their first port of call, given that issuing a court claim costs. And there will be time limits. You will have obligations to deal with serious hazards. It won't just be damp and mould, but those are the main ones, because that was the subject of this young man's case. Sorry. And then there will be penalties if you fail to. The way that this is going to be, I believe that the way that this is going to be enforced and the rules around it are still to be decided. I think regulations are going to decide this, but I think there's going to be reform that's probably going to apply to social housing as well. So we don't know exactly what the strict rules about this are going to be, but there will be obligations here. And then in terms of records, I would say the usual photographs, written records, inspections should be thorough and well documented. Your inspections, as I said before, are going to be, I think, all the more important because of the pressures that are going to be on you and the obligations that are going to be on you. When will the bill come into effect? I think we can whiz past this one, we've discussed that. Can I take rent in advance, 6 months for example, or termly if a student, if it's a student let? The answer is no, you can't. If you do, you could be in trouble. There could be penalties. I would suggest that if that does happen for whatever reason, if it's overlooked by anybody, an agent or somebody's dealing with something for you administratively, pay back. If you take 6 months, for example, pay back 5 as quickly as possible, and correct things. You can take 1 month's rent in advance, and there will be a prohibition on accepting any payment in advance, even if the tenants offer to pay more. And sometimes we know that that's an issue, and that's a way that you can get around, for example, bad credit, or a tenant not having a strong covenant, let's say. That's not going to be possible anymore. And again, at this moment, I don't see any way around that. The tenant can pay. They can pay their rent in advance if they want to pay their rent in advance. Once the tenancy started, that's a different thing. But certainly in the initial period, when you're starting the tenancy, you will only be able to take or require up to 1 month's rent. The 28 days is for tenancies of less than a month, so weekly tenancies, for example. The landlord, once the tenancy starts, the landlord will be able to enforce any terms. Will be unable to enforce any terms in the tenancy agreement that require rent to be paid in advance. So they'll just become redundant. But as I said, tenants will be free, however, to pay in advance if they wish to. If I can't take rent in advance and tenants fail referencing, will tenants be able to rent properties? This is obviously a question from the tenant's point of view, but also it's from your point of view, I guess, because it knocks out, because the answer here is no, unfortunately, and it knocks out a percentage of tenants out there who would otherwise be renting with you now, just with some special measures in place. You may be able to, I guess, be creative about this and find other ways, guarantors, but you're still going to need to do your due diligence, I would say, thoroughly, and I think that's going to be something that's going to be all the more important, again, is how you choose your tenants. So you won't be able to, you'll only be able to take a month in advance, and there is no way around that. The government's view is that the benefit of preventing undue costs to most tenants far outweighs the drawback. So again, it's supposed to be tenant friendly. How do I go about increasing the rent, and how often and by how much? Do I have to issue a section 13 each time, or can I add it into the tenancy and expect it to happen without notice? So you won't be able to add it into the tenancy. There'll be no contractual rent increases anymore. If there is anything in a tenancy agreement that you issue, it will be redundant. You will be able to do it once a year, and it will have to be to market rent. You'll need to serve a Section 13 notice, setting out the new rent and giving at least 2 months' notice of it taking effect. Any rent increase, rent review clause in tenancy will not apply. And so the rent can only essentially be increased by either you serving the notice with the proposed new rent, or the first tier tribunal making a determination of the open market rent under Section 14. And this could be two ways. The tenant could take it to the first tier tribunal at the start of the tenancy. I think they've got 6 months, they'll have 6 months from the start of the tenancy to challenge the initial rent. And so the first tier tribunal will be able to make a determination on whether the rent that you've set and the tenants signed up to and agreed to is within market rates or not.
They've signed up to it.
Yeah.
They agree to it.
Yeah.
And then they can go.
Yeah, they can challenge it, and it will go to the first tier tribunal, and the tribunal will hear it and make a decision on it, a determination, and you won't be able to challenge that. And the way that it's changed also is that the way that it is now is that under the Section 13 process, if the tribunal decides that the higher rent, that the rent should be higher, it will be higher now. But here it will always be the lower of the two. So you know, again, it's on the side of the tenant. Or they can challenge an increase in rent, an increase that's been included in a Section 13 notice. And again, it will go to the tribunal, and there'll be a determination. The increase cannot take effect until at least 52 weeks, so they're protected, that rent is protected for the first year. I imagine this won't be so relevant to most of you. In the HMO market, if a tenant wants to leave, do they all have to leave? Can they insist that I renegotiate the rent? What fees can I charge a tenant if I have to draw up a new tenancy agreement, i.e. a change of sharer? In this context, I'm assuming that it's a joint tenancy, so it won't be individual HMOs. If so, because of the fact that all tenancies become 1 month periodic tenancies, they won't need consensus among the other joint tenants. One HMO tenant will be able to, so one student will be able to bring the tenancy to an end by serving 2 months' notice. That will bring the whole tenancy to an end. What they can't insist that rent isn't renegotiated. They can't do that, but they can request the remaining tenants can request either a new tenancy agreement that doesn't include the leaving tenant, or one that includes a new tenant, or a variation of the tenancy, or a novation. I would say, you know, this steer clear of this if you can, because it can be quite complicated. Novation is essentially, you know, replacing a tenant, so you're keeping the same contractual agreement but replacing. I would say a new tenancy is best here. So if you have go ahead.
If you start a new tenancy, you've still got the 12 months business, haven't you?
Yeah, you're starting a new tenancy. You start from the beginning, absolutely. So it's going to be tricky if a tenancy starts in September, and then in theory, in December, one of the tenants, you know, they can have an argument about something, and we know this happens with student tenants all the time. They can serve you notice. They're out by February, and then you've got from February until June, let's say, or July, where you've got to work it out again. And you know, if you're renting to let's say you're renting to 5 tenants and your rent is 1,500 quid a month, so they're paying 300 quid each, and you're obviously not going to be wanting to rent it for 1,200 quid because that's just not, you know, the value of your property. So they're either going to need to find someone else, and then you grant a new tenancy.
So then that be for the whole 12 months?
Well, it won't be for 12 months. It will be a periodic tenancy, so it will be exactly the same. Yeah. So you'll be starting again, but it will be on a monthly rolling. So, but then they will have the same ability to serve notice again. You know, so this is an ongoing thing. I guess you do have 4A on your side, so that just in case when summer comes, there are any issues, you can rely on 4A and serve notice to bring the tenancy to an end and get possession. But again, you know, we'll have to see how that plays out. And then in terms of fees, at the moment, the statute, the Tenant Fees Act, caps payments at £50 for this type of payment or reasonably incurred costs. So if you can argue that preparing and signing up a new tenancy costs more, then you can charge more. Sorry, go ahead.
If it is, say, 5 tenants and one gives notice in December, what stops the others from just saying, we're not going?
Well, I mean, the tenants have brought
One has brought it to the end.
but one's able to bring it to the end. There's only one contract.
But if they just physically say, we're not moving, we want to stay.
Well, then you're going to have to go through the process of removing them.
Can you?
Well, you can legally through court.
Not before 12 months.
The,
They haven't been there for 12 months.
the possession process. I would say once you so obviously once you're entitled to issue proceedings and a claim, you will usually get a hearing at the moment within 3 months. Let's say that's obviously money that you're losing if the reason that they're not if the reason that you're issuing the claim is because they're not paying rent, then you know that's going to be issued, and I think it's going to get worse. I have to say, I'm sorry to say, because one of the things that you're going to be up against is that the current ground 8, which is for serious rent arrears, as many of you will know, is currently 2 months, at least 2 months on the date that you serve notice and the date of the hearing, is going to be 3 months under the new law, and the notice period, which is currently 2 weeks, is going to be a month. So technically, you could be 4 months down before you can even issue proceedings, and then you issue proceedings and you're waiting. Let's say it's 2 months, and you get a hearing, and then you're hoping to get the possession order. So you're 6 months down the road now with no rent. And actually, this has reminded me that Jenny was talking about rent protection. I can't agree more that's something that will give you peace of mind, to the extent that it can, because these are real issues that many of you know more about than I do. So I think it's going to get worse. And the other thing I have to add here is that the statutory provisions and the statutory considerations are increasing with this law change, but there are no signs yet, no real signs that the government's going to ease the pressure off the courts. they're quite overwhelmed as it is. In the southwest here, we're not as bad as we are in the southeast. I mean, we have some London cases that we deal with, and some of the courts in London, forget it, they're completely on their knees. So I think we'll see again how it plays out, but I think that there's going to be even more pressure on the courts, and that's the reality. It's one thing to be able to use these statutory provisions and use these grounds and work out how to use them best and how to issue tight and very well drafted proceedings and get it right from the beginning. But the reality is that there are delays, and that's something that you'll need to deal with cash flow and that sort of thing. When will be the last day I can serve a Section 21? Well, you can serve one at any point up to the date on which the bill comes into force, the commencement date, as they call it. And as long as the Section 21 notice is validly served before the new legislation comes into force, and that's very important because we know, we deal with Section 21 notices that have been invalidly served all the time, and we have to start again. And now, as it stands with the current law, we have the time, we have the ability to do that. It's just time for you that we're saying to landlord clients, unfortunately, we wouldn't issue proceedings on this basis, because when it gets to court, the judge is going to pick holes in this and find that you didn't serve all the gas safety certificates, and you didn't serve the EPC, and you didn't give the prescribed information and all the other requirements, and it's just going to get thrown out and you're going to start again anyway. So we would recommend that we issue a fresh notice and start again. Here, you're not going to be able to do that because you've got one chance. So if you're presuming that we're talking about serving a Section 21 notice just before the law change, and you've got 6 months, as you know, from the date of service, that 21 notice will be valid. So that is obviously becoming more and more of a consideration as we get closer to commencement date. And then the AST should terminate in accordance with the notice and will not convert into a monthly periodic tenancy. That will keep it as an AST, essentially, whilst that notice is live and those proceedings are still going through the courts. When it comes in place, so when it's enacted, what if I have taken rent in advance? Do I need to refund it? Simply put, yes. We discussed this already. You really need to be, after the law comes into force, if you find yourself in that situation, pay back the rent, because I think, I presume that some of the penalties are going to be, some people are going to be made examples of to get things started and really establish the new law. When the law change happens, and I have already let the property and signed the tenancy agreement with more than 6 months before it starts, is that going to be okay? Yes, you as landlords will be free to agree tenancies ahead of a start date, but will not be able to take more than 1 month's rent. A lot of this we've discussed already. You'll need to be mindful of the ground 4A. Taking rent in advance is a tricky one in this scenario. We would advise that you do not do this as we near the enactment of the bill. Strictly speaking, there will not be retrospective application in this regard, but it's one that we as lawyers have not really been able to get a clear answer on, as to whether if you take rent in advance, let's say you take it today and then it's enacted in July, that tenancy will convert to the new type of tenancy, the periodic, and technically it shouldn't have retrospective application, but we know that in many other areas of this bill there will be retrospective application, and that's things like the fact that existing tenancy will be affected by rent increase law. So if that happens here, then you'll need to be mindful of that. So I'd be very careful the closer that we get to commencement date.
But we don't know when commencement day is.
We don't know
It's
yet.
July, as in it's the next month.
Well,
Then I will know next year.
no, July is when it goes to the House of Lords for the report stage.
Yeah.
And then it will come back, it will start ping pong, so it will come back to the House of Commons. But then, as I said, there's summer recess, which I think is on the 22nd of July, so you've got, what's that, 7 days, and nothing's going to happen in that time. Then the Houses of Parliament come back on September the 1st, so the very earliest we're looking at is November, 2 months after that, and it's not going to happen then. So you've still got some time, but I would just be mindful of this.
If you actually took it when the students come in, and you asked them to pay the whole term agency did.
Of rent, yeah.
Rent, could you, before it came in, pay that back and then still be, so if you've taken the 6 months or the term, could you then pay that back to them and say, okay, actually, I've got to change that? And
You could.
all those things.
I guess what I'm saying is we're not sure if you would have to or not, but if you err on the side of caution, then yes, if you want to clean things up and be prepared.
Yeah.
But we're going to find out. We're going to find out because all of these questions are going to have to be answered by judges or local authorities or ombudsmen, and so we will find out. Yes.
This legislation I read somewhere is similar to the legislation that they've adopted in Scotland. How does it work in Scotland? How is this been?
I know very little about Scotland. I know, but it's really not. It's not something that I ever have to work in. So I couldn't.
Do you know if it's similar? And one
There are some similarities, yeah, but again, it's not something that I'd be able to say much on. Okay, if I have already taken the damage deposit when the law is enacted, but the tenancy doesn't start for another 8 months, is that okay? Again, as long as you protect it within 30 days and it's not more than 5 weeks rent or 6 weeks if the annual rent is more than 50k. But again, we're coming back to ground 4A. Do I have to issue anything to the tenants when the law changes to let them know the new rules? You won't need to reissue existing tenancy agreements, but you will need to serve a formal notice to tenants within 1 month of the bill going live explaining the change. This is the important one. A written statement will be required on new tenancies before the tenancy is entered into. And this is different to the tenancy agreement. It's a statement, it's almost what you would have as heads of terms when you agree a transaction. So it will set out the parties' rights and obligations and the key terms before agreeing to the tenancy. And it should have basic information like the rent and the landlord's name and address and so on.
Can I just ask?
Yeah.
Is there going to be a printout form like?
A prescribed form for.
There's just outlining the changes
Uh,
to a tenant. We can say to a tenant, this is what's going to happen now.
That's a good
We've
question.
got to draft it ourselves.
You mean as in the prescribed information that you have
Yeah.
now, or the how to rent booklet, that sort of thing? That's a good question. I can come back to you on that. I don't know.
I mean, at the moment you have like section 30s and different
Yes.
like that. So otherwise each landlord's going to be doing different information.
Yeah, I imagine there will be. I'll be very, very surprised if there's not. And even if it doesn't start that way, I imagine that very quickly that will become the case. That there will be prescribed information, and I imagine that that will be something that you will serve with the tenancy in the same way that this written statement, the written statement, will be probably part of the tenancy agreement, because as long as it's done before the tenancy is entered into.
No, I'm talking about existing tenants.
The information that you have to give them.
We've got long-term tenants.
Yeah. Okay. I'm not sure. I'm not sure if there will be, if the government will issue a prescribed form or letter. I imagine so, but I can come back. I can certainly come back to you on that.
You know, one landlord
Yeah.
doing one will be doing the other.
What will be the case is that there will be a minimum. There will be information, absolute minimum required information that you will have to give, and I think that will probably deal with the issue of different landlords giving different information, you know. But yes, I would imagine that having a prescribed letter or a booklet of some kind, like the How to Rent booklet, is probably going to be the way. That I would imagine so.
So what happens with, you know, the 12-month thing with students? Like ours are there for 11 months. So will they be expected to have to give us notice? Because obviously they'll want to leave in July, they're not going to want to stay an extra month.
They will the normal HMO tenants. I know that it will work differently with students in purpose-built accommodation, but with normal HMO tenancies, they will be periodic tenancies. They will be 1 month rolling tenancies, so there won't be a 12-month contract.
But they have a 12-month protected period, don't they?
Oh yeah, but that's protection. So you're subject to that. They can give you notice whenever they want.
Yeah, but they will have to give us notice.
They will have to give you notice. Yeah.
Okay.
Yeah.
So we'll have to tell them that at the beginning of the tenancy.
Yes.
That you'll have to write to us and say.
Yes. Yes. Exactly.
Okay.
They'll need to give 2 months. Yeah. Yeah. They can give 1 month now when it's outside of the term. In the summer you can, yes. Yeah, absolutely. And you won't be able to. That's a good question. I think you will be able to rely on the 4A, and I think that's the point of the 4A, is that you will need to be able to rely on that ground to bring the tenancy to an end in the summer, because that's obviously part of your model.
You've already rented it for a whole month, and it starts the 1st of September, so you're going to have
Yeah, absolutely. But I guess
I don't know how potentially it could look very quickly for you. Bit of an idea in a minute, you know.
you were going to ask a question.
You have to give 2 months notice within the first year, within the first 12 months. We want to give ours by the end of July. September. You're not going to notice 2 months notice before 12 months, before they leave there 12 months.
Well, the 12 months. Yeah, you can, depending on the ground that you use. You know, because the point is that there will be new grounds and there will be existing grounds. You have to rely on Section 8 and the grounds in Section 8. And there's a whole list of them. There are some new ones. There are the existing ones like rent arrears, and the normal 3 rent arrears grounds.
You can't just say at the beginning of May, you want them out at the end of June, or let's say at the beginning of June because you want them out at the end of July. You can't just say
No, there needs to be a
July because our next students are coming in on the 7th.
there needs to be a reason, and the closest to what you're describing is 4A, that you will have a window in the summer, and I believe it's July to September, and in that time you will serve notice and seek to get them out during that time.
So you can use 4A even if they haven't been in for 12 months?
Yes, I believe you can.
Is it not only if it's an HMO though?
If it's a student HMO,
So if it's less than 4 people, say it's not an HMO, but they're students.
it's still a HMO. It just might not be a licensed one, depending on the local authority. So I think a HMO requires three from
So
different
This is a 2-bedroom.
different dwellings. Yeah. I have a 2-bedroom property which I let to students, as I won't be able to give them notice. Is this correct? Will I not be able to let it until the tenants give me notice? In this case, then it's not. Presuming that there's one per bedroom, it's not HMO. They will have a 12-month protected period. They will be able to serve notice on you, 2 months, and this must be in line with the rent payment date. You won't be able to re-let or remarket property for letting for a restricted period from the date the notice is served until 12 months from the later of the relevant date in the notice, which is 4 months after the notice is served, or the date on which a claim form or particulars of claim are filed with the court to bring proceedings to possession. Yes. At what point can I serve notice if my tenants stop paying their rent? This is ground 8. It's available to you now. Well, it's ground 8, 10 and 11, but you probably are aware that ground 8 is a mandatory ground, so if you're able to make out the requirements of ground 8, then the court has to make an order. But then we usually, when we issue proceedings for non-payment of rent, we throw in 10 and 11 because they apply too. 10 is any rent arrears at all on the date of service of the notice and the date of the hearing, and then 11 is persistent delays and rent arrears. So with underground 8, it will take longer. As I said, we've now gone to 3 months rent arrears are required. It's currently 2, so 3 months will be the new serious rent arrears, and then it's gone up to 4 weeks' notice rather than 2 weeks' notice. So I think that's going to be a significant change because that extra time will matter when it comes to cash flow. When will a landlord be able to turn down requests from tenants to keep pets? We've kind of covered this already, but I think it's worth revisiting because I think it's something that you're all going to need to consider. So they're allowed to ask for permission. Each case will be considered on its own merits. So you'll need to show that you've considered the request fairly. You'll need the burden of proof will be on you to show why you're refusing, rather than the other way around. They haven't got to show that it's reasonable, that it's a reasonable request. You've got to show that it's a reasonable refusal. Go.
If there's a house in multiple occupancy, by the way, this is an utter disaster, and I'm sure that, like me, a lot of people are completely lost on this. It's so complicated, and it's not unsurprising that PBSAs and halls of residence owned by the university are exempt from this, as they are with HMO licences. Is there any way we can simply avoid this by using a licence to occupy, which is what PBSAs use? Because that would be a really good solution, because it then none of this would then apply.
I don't know about that. What I would say is one of the things that I think is going to be relevant here is that there are going to be exemptions to this law.
This is just one of the clauses.
This is just one. But
by the way, there's a number of people. Sorry to interrupt. But I'm really steamed about this because this is an utter disaster. Utter disaster. If you've got more than one tenant, like in a student house, you've got 6, 8 people. One person wants to bring a pet in, but the others don't agree. That, to me, is a reasonable ground to refuse a pet, but it doesn't appear there.
But it could be. I mean,
how do we know?
This is the thing. It's new law. We're going to have to find out. You know, these cases are going to need to be heard, or local authorities are going to be making decisions on these, or or the ombudsman, and as is often the case with completely new law, and this really is new terrain. The hearing of these cases is going to be how we're going to find out how the laws are applied, and unfortunately that's not something we can get around. It is, and I personally don't understand, and I think I probably speak for many of my colleagues, in the way that we discuss how how too much protection for tenants is going to actually play out in the market, because
It's gonna
we
reverse
know,
it, isn't
yeah,
it?
we know what the risks are. You know, those tenants need housing, and they need you to be
Wanting to do that.
confident in the housing, in the legal system, to be able to go forward and provide that housing.
In Scotland, where it has a similar rule, a similar law has been passed, it's a real disaster. There's a dire shortage of all types of rental property in the sector, students and other letting. It's a disaster. I just don't know how this can possibly go through.
What I was going to say about this was that there are going to be some exemptions here, and one of them is, for example, if your insurance policy is going to be breached in some way, and the other one is superior landlords. So let's say, for example, you are just a head lessor, you're not the freeholder, and so you have a head lease. If your superior landlords, if that head lease prohibits you from having pets, then the same obligations of reasonableness are not on the superior landlord, if that makes sense. How and why I don't know, but it's just that at the moment that's how it's forecast to be enacted. So you know that's one of the exemptions. Make of that what you will.
They should have really done it totally different for students, because I mean most students, not all obviously, but most students would not cope with having a pet in the house. You know, they don't get up in the morning. They're out all the time. They're out till 3 in the morning. You know, who's going to take the dog out? Nobody.
And the real issue is that you don't actually have to own the pet to make this request either. It can be someone else's pet. Yeah, a pet that you're taking care of. So, sorry, go ahead.
We have a house that's got 6 self-contained flats.
Sorry, I missed that. Can you?
We have a house that has 6 self-contained flats.
Yes.
And we would argue, no, you can't have a pet because they could be at work all day and you've got a dog barking.
Yeah.
I mean, to me, that's a reasonable exemption.
And I wouldn't argue with you. You know, I would
Because
say.
it's going to be upsetting 5 other tenants.
But again, you know, the courts may actually turn out to agree with you, and I do think that insofar as the courts can be, they do try to make sensible judgments. Let's see how it plays out. I know that you all want more than this, more than we can discuss today, but it's.
Ridiculous law.
What if a freeholder is stipulated in covenants their convenience?
Exactly. Well, there's no requirement of reasonableness on the freeholder. If that's the superior landlord, and then you are, but you. Did I do that? No. It might be that you plug. Yes, you are. Yeah. Continue watching.
Continue watching.
No, it's not on the computer.
It's not letting me, because I think this is just. Yeah. Okay.
I think,
Should
to
we-
be honest, we've both agreed.
Yeah.
Gone over time. I mean, if everyone's happy, we can get these questions put down and sent over to you all. If that all sounds good. We can sit here all night for you.
And again,
We don't need to know the details of this legislation yet.
Yeah,
So
and if
this
we-
is all hypothetical, really.
if they don't and they don't, how can we and then how can you?
Precisely. I mean, it's a warning notice in advance, but there's nothing I can do
Yeah.
until we've got all the actual legislation needs to come to law. Well, or at least is through Parliament. And you've got to backing regulations.
And I think that the Labour government's very eager to get this through on their clock. You know, they want to be the ones that have got this through, for the tenant. And I think for political reasons, it's going to be an issue, as it always is. Yes, sorry. You,
Is at the end of joint and several liability?
No, it's not.
So when we have a discussion about one leaving,
That is exactly that
It's
principle
already
that brings it to the end, brings it to an end.
But we're doing this all the time anyway, I don't know you, but we have tenants that fall out, you know, even before the tenancy starts in September.
But they're joint and several, aren't they? And
They are,
they find the tenant.
Yeah, they
you
find
have
But we always allow them, you know, very rare would we keep them there for the whole year and insist that they pay rent. We will then push them to try and find a new tenant. So I think it's going to be, it will settle.
Responsible for the rent.
They are,
They
well,
are, yeah.
as it stands now. Let's say you've got a student tenancy, you know, for a fixed term for 9 months, let's say, and one wants to leave. Now, because of the joint and several liability, if they just took off, the remaining 3 or 4 are all individually and collectively responsible for the rent, you know, for the whole of the rent.
Yeah.
I rent to young professionals, and I issue ASTs to individuals within an HMO setup.
Yes.
What complications do you see there?
Well, that's obviously not going to have the same issues that we're discussing now, because if each one has a contractual relationship with you,
Yeah.
they are the only other party. It's you
Fine.
and one person, let's say.
Yeah.
You know, or if you're renting to a couple, then then they have a joint tenancy.
Yeah.
But all the others can be HMO. They can be HMO tenants, but with individual contracts, so they won't be affected
Fine.
by the others.
Thank you.
I did want to say something about the license question, because the only thing that you've got to be careful of is that with the contractual with the contractual document, it's substance over form. So whatever you call it, if everything about that contractual relationship is a tenancy, then that's how it would be treated by law, even if you call it a license, even if it says license on the front.
But PBSA seem to be able to get away with it.
Yeah.
How do they do that?
How do they get their exemptions?
Yeah. Well,
It's same like the councils. You know, my son's partner or girlfriend who had a flat. There was asbestos. They lifted up the tiles, the asbestos tiles. They were all cracked and stuff, and it was just left like that. And they phoned the council. They didn't have people in, and they had broken tiles and children. So and the other council had the polystyrene ones that had been painted. You know, school-wise. Teen school, they put a brand new block which had 5 classrooms and not a single toilet in it. How did that work, you know?
That's the sort of standards they
well, I do want to say thank you. Sorry, everyone. Should we take one more?
I was going to say, I think Cara was going to say something at the end about what a
Yeah.
Shall I hand this to you and say thank you to everybody? And if you have any other questions, then you read them through Cara.
That was tough. Thanks, John. Thanks a lot. I have just got a few things just to try and finalise it and make sure you don't all go away needing to hit the ball of gym when you get back home or something. I hope that's cleared up a few of the questions or things that are concerning us. And we're all here because we want to learn and we want to educate ourselves, don't we? And I hope if you just go home learning one thing, then this event has, it's done a good job. So, just a couple of things. For those of you with long-term mainly residential tenants, if you've got tenants that pay your rent on time, they look after your property and you've got a good relationship with them, I don't think you really have to worry too much. But relationship is key, and being hands-on, responding promptly when issues arise is going to be absolutely vital. Moving forward, if you don't have that kind of relationship with your tenants, then I really think you need to start thinking about changing that. Start building trust. Start building good communication from day one, from the day that you let your property. That is going to be really important. And the same applies to student lets. The same principle. You've got to build that relationship up from the beginning. You've got to be even more hands-on when it's with its students' tenants. I've had to show tenants how to change a toilet roll and a fixed toilet fitting once, and even how to turn the washing machine on. So we've got to be hands-on. You've got to really build on that relationship. But the last thing we want, especially for students, is for our tenants to leave mid-tenancy. We were just talking about one bringing a tenancy to the end. They're not all going to want to go. There's not going to be accommodation around for them to go to. yes, one might leave. Hopefully they'll find a new tenant moving in. I think we're going to see more tenants, individual tenants looking for properties. So I think, that's going to be a benefit to us as well. So we can get around that, but we don't really want the hassle of having to renegotiate with a new tenant. We don't want that new tenant to move in and then upset the rest of the house, and then one more leaves, and 2 months later we've got to go through all of that again. So it's really important to make sure your tenants are happy throughout their stay. And I think, just that building up on that relationship is really going to help on that. Now, how is post-renters reform, how is this renters' right going to work in the student world? And I know that's what's worrying a lot of us. Believe me, we've been talking about this for a good few years in our office. Now, we're talking about 3 properties with 3 bedrooms. That's a HMO. Forget the licence bit. If you rent to 3 tenants, you've got a HMO. So we're just talking about those properties at the moment. Under the new changes then, we are no longer able to control the end date of the tenancy. Yeah? And that's a huge shift here, isn't it? So it means that we could be going from an 11-month tenancy, which is what most of us do, possibly down to 9 months. If they leave in June, and they'll get the exams out of the way, have a few parties, they could potentially be going in June. So we could be down to a 9-month tenancy. Because will they want to keep paying their rent? Even if they're due to graduate in July, are they going to want to continue paying their rent? They're likely to hand their keys in and pay for their B&B for grad week. Let's just say that does happen. That leaves us with a 2-month income gap. The question is, how are we going to maintain our rental income, when we can't control that end date? So one idea that's been circulating, we talk to other agents, we talk to, landlords like yourself, bigger portfolio landlords as well. And what we can do is control the start date. Now, if we could get the tenants to start a month early, okay, this is just hypothetically, it's just chucking a few things out there. But if we started the tenancy a month early, then we've gained 1 month rent. Now, if everybody did this, we've been talking to agents, and without us even having to mention it to them, this is what a lot of people are thinking. Now, if that comes to norm in Exeter, then that's the normal. That's what we have to do. Tenancy starting in August, and that's what it is. And we've gained a month's rent. So that's one way. And then the extra month, I think what's going to happen is the rents are going to have to go up slightly. Spread that out over the remaining months. I think, this is what they've done in Scotland. I've spoken to a few agents in Scotland, they've had, similar things to this as well. So that's what they've done. So start the tenancy early, 1 month early, and then for the final month, we're going to see a loss, bring the rents up slightly, and that's how we can recoup our loss, and we can all make sure that we're still receiving the same income. Because if we're not receiving the same income, the model doesn't work. I presume we're all going to want to leave, aren't we? Unfortunately, for 1 and 2 bedrooms, I think we were just coming as the laptop shut down there. 1 and 2 bedroom properties, they're not HMOs. So what it means is we will not be able to, we won't be able to give them notice to leave. So if we're talking about the bigger HMOs, we know we can give them notice. So if they're not going to leave, we can give them notice to leave. But the likelihood is they're going to leave in June. Yeah. But our 1 and 2 bedrooms, we're going to have to wait for them to give notice before we market the property. So that's going to be the difficulty there. But most 1 and 2 bedrooms are masters, tenants with masters, doing masters, postgrads, and they don't tend to look until March, April. But if you've got that good relationship with your tenant, you can start talking to them and actually find out what they're doing and get them to give notice, so you can get the property marketed. So it is going to be a bit difficult for 1 or 2, but at the end of the day, like John was saying, the devil's in the detail. We don't really know what that is yet, so, but it will be fine. It will be fine. So just one more thing. I know we were talking about purpose-built blocks, and they don't have to comply with this bill, and they can carry on with fixed-term tenancies. And at the beginning, a few of us are going, well, that's not fair. It's not fair. But actually, it could be to our advantage, because what tenants are going to want to sign for 51 weeks? What tenants are going to want to move in September and know that they're fixed until the following August? So it's a possibility we might see some of those tenants move over to our market, our HMO markets, because they know that we can let them for a short period.
There's no requirement for them to offer a 51-week tenancy. They could offer a 48-week tenancy in PBSAs.
Yeah.
They're
They're going to have to adapt, aren't they?
Well, they have complete flexibility.
Yeah.
They can get rid of tenants. They can have whatever length of tenancy they like. And in my view, we, private landlords, should have the same advantages they do.
Yeah. I agree. We all agree in this room, but unfortunately we're not being listened to. We've all written to our MPs. I've written to our MP.
I was going to try and finish without all doom and gloom the way
Yes.
you are.
Yeah.
Because I do think there are some things to possibly look forward to, or to be confident, a little bit more confident about, or optimistic about. I mean, one, for example, is that I've never done so many Section 21 possession claims than I have in the past year. You know, so many landlords are coming forward trying to get in before the law change, to get their properties back for different reasons, because they want to get out of the market. You know, some want to get out of the market. Some, you know, want to just change the way that they're dealing with the property. You know, to do short-term lets and Airbnbs and that kind of thing, holiday lets.
Yes.
But what that's done is that it's caused the landlords that do want to stay in the market still, who are not jumping ship because they're not getting too frightened, to stay and become fewer, because that's obviously what's going to happen. And then the law of economics, we know, supply and demand, it could have an effect on the rent going up. I've heard landlords that, you know, I've heard a colleague, well not a colleague in my firm, but a lawyer in another local firm who's got a significant portfolio, who said to me at a recent networking event, great, I'm putting my rents up. You know, that's what's happening. So, you know, there's a possibility that rents are going to go up.
Can you do that for however much people?
Yeah, sure.
It's the southwest.
Yeah.
We have tenants that have been there 20 years. And students.
But if the open market rent, I'm saying, if that
But you
goes
can't
up,
get blown over the stone. And you want people to be happy. You know, if you've got a house of 6 tenants.
But then even if it's not about the value of the rent, even if it's just the fact that there are fewer landlords, meaning that tenants are going to be possibly more careful and more protective and precious of their tenancy, means that even if you get a percentage improvement in the way that tenants present in that relationship, that's a positive.
I would like to say we have a good relationship.
And I think a lot of the good practice that Cara's talking about is stuff that you know more about.
Otherwise we wouldn't have tenants in there 20 years.
But if you've got that good relationship with your tenant, you know, I know it's worth a lot, especially residential landlords. You know, we've spoken to landlords who thought, you know, haven't put the rent up for years. We're saying put the rent up, but it's more important to have a good tenant.
To have a happy spouse.
Exactly.
And
you're going to
shoot for another £10 a month.
Yeah, and you know, if you've got that relationship with your tenant, you'll have no problems. You know. So I think, you know, it's just a matter of waiting. I think we need to wait and see how things go. But you know,
I think it's biased to the tenant.
Yeah.
Always definitely fine. Well, it never used to be, not like it is now.
There is a Labour
Far
government.
more biased.
Really?
At some point.
Very optimistic.
I think in summary of tonight, what we need to do is make sure we build on, you know, on relationships, stay hands-on, you know, adapt early to these coming changes. Obviously, looking at EPCs as well, make sure you're improving on those ratings as well. And if we do this, we will survive these changes. You know, we'll thrive in spite of them. You know, just my last thing to say really is, if you're overwhelmed, you know, we do have one remedy, and there's some Paracetamol or Racecourse on your chair. Okay, and that does help just a little bit. Look, if you want to discuss any of these topics with us, we love talking at our place. You know, please give us a call. Honestly, like I said earlier on, give us a call. You know, we'll pop out and see you. You can pop in for a coffee. There's no obligation. All right, and we've got a lot to learn. We've still got a lot to learn, and we'll see what happens by the end of the year. All right, and I think everyone's most probably ready to go home now. So thank you very much for coming, and safe journey.
I left my pen on the chair, but it seemed to have gone missing.
You do get chance to fill them in.
We did discuss.